So till now we have discussed what is a contract of sale, what are the various essentials of a contract of sale, and what is the role of the subject matter and price in the contract of sale. Next we come to the another concept, that is conditions and the warranties. When a seller sells the goods, at selling the goods, the to induce the buyer to purchase the goods, a few representations are being made by the seller. To the purpose of those representations is only to induce the buyer, and such representations, if are not the part of the contract, there are no legal consequences for that. But if those representations are forming the part of the contract, that means it comes into the stipulation of the section 12 of the contract of sale 1930, then it may be treated as a condition or a warranty for a particular contract of sale. So now what is a condition, what is a warranty? Section 12 subsection 1 explains it: a stipulation in a contract of sale with reference to goods which are subject matter thereof may be a condition or a warranty. That means to induce the sales, what kind of representations are being made. If those representations have become the part of the contract of sale, then it is called as condition or a warranty. Now let's see them in detail. What is the meaning of conditions? Section 12 subsection 2 defines it: a condition is a stipulation essential to the main purpose of the contract, the breach of which give rise to a right to treat the contract as repudiated. Means a condition is a representation, condition is a stipulation which now have become the essential part of the main purpose of the contract. Means in any case, if there is a breach of condition in any contract, the other party has a right to repudiate the contract. Basically the buyer and seller make the statements just to induce it, but once these representations have become the part of the contract, it would lead to legal consequences, and these legal consequences, if are being involved, then its breach may go for some legal consequences in the form of repudiation of the contract. Basically what happened, when the statements are there in the praise of goods, let's say for example the statements are just to praise of the goods, that means goods are very nice, it's very tasty, hence these kind of statement doesn't make any kind of legal consequences, and they are not the part of the contract. But the statements made by the seller which become an integral part of the contract would definitely lead to the legal consequences. So to treat a stipulation, to treat a representation as a condition, the following essentials must be fulfilled. One of them is it is essential to the main purpose of the contract. Next is that the non-fulfillment of condition will cause irreparable damage to the aggrieved party. That means if the condition is not fulfilled, it would make irreparable damage to the aggrieved party. So the fulfillment of condition is required. Third is breach of condition gives right to the aggrieved party to resign the contract. Means in case the condition is not fulfilled, the other party can resign the contract. So now let's talk about the warranties. What is the meaning of warranty? Section 12 subsection 3 explains the meaning of warranty. A warranty is a stipulation collateral to the main purpose of the contract. Whereas condition was the main purpose of the contract, warranty is a collateral to the main purpose of the contract, the breach of which give rise to a claim for damages, but not to a right to reject the goods and treat the contract as repudiated, which was possible in the case of conditions. That means in case of breach of condition, a person can repudiate the contract, but in case of breach of warranty, a person can claim only for damages, but the other party don't have a right to reject the contract. So what are the essentials of a warranty? It is collateral to the main purpose of the contract. The breach of warranty causes damage to the aggrieved party, but does not defeat the main purpose of the contract. This is a major difference between the condition and the warranty. Third is the aggrieved party can only claim the damages for the breach of warranty but can resign the contract for breach of conditions. There is a case that is Hetley versus Hemans. A man buys a particular horse which is warranted quite to ride and drive. If the horse turn out to be vicious, the buyer's only remedy is to claim damages, unless he has expressly reserved a right to return it. But if instead of buying a particular horse, a man applies to a dealer to supply him with a quiet horse, that means he had made a condition that he needs only a quiet horse, and the dealer supplies him with a vicious one, the stipulation is a condition. That means if there was a condition applied, the condition posed by the buyer at the time of the purchase of a horse that he needs only a quiet horse, in that case, if this condition is being not fulfilled, the contract can be repudiated. But if the buyer has a particular horse which was warranted that it is quite to ride and drive, so in that case if it doesn't proves, then the buyer can only claim damages. That means in case if there is a condition, the buyer can repudiate the contract. If it is a warranty, buyer can only claim the damages. Now let's see the difference between the condition and a warranty on the basis of difference importance in contract. Condition is an essential part to the main purpose of the contract, whereas warranty is a collateral to the main purpose of the contract. It is not the main thing. Consequences of breach: if the condition is being breached, the contract can be repudiated and the claims can and the claim for damages can be made. But in case of breach of warranty, the aggrieved party can only claim the damages. Third is option of treatment. In case of condition, breach of condition can be treated as a breach of warranty as an option. Means the buyer can even accept the contract, but it would be treated as a breach of warranty as an option on the part of the aggrieved party. But in case of warranty, breach of warranty, there is no such option available to the aggrieved party. So this is a difference. When condition can be treated as a warranty, it is explained by section 13. One is voluntary waiver by buyer. In case of default, the buyer has the right to repudiate and reject the contract, but he can elect to waive the condition too. That means when we can treat the condition as a warranty, and the buyer would not repudiate the contract. The first case we are going to discuss is a voluntary waiver. Buyer has voluntarily waived the condition. Let's see the example. Mr. X agrees to sell Mr. Y 100 bags of a particular quality of basmati rice at rupees 4500 per bag. But he supplied second quality basmati rice at rupees 3500 per bag. It is a breach of condition because the condition was of first class basmati rice of 4500. But what is being supplied? That is second quality basmati rice at rupees 3500 per bag. So it is a breach of condition and the buyer can refuse to accept the delivery by rejecting the goods. But if the buyer elect to treat the breach of condition as a breach of warranty, he can accept and claim damages at the rate of difference between, that is rupees 1000 per bag. Second is treating the condition as warranty. Let's see the example. X agreed to supply Y 5000 meters of fine cloth at the rate of rupees 30 per meter, but supply only the medium quality, the price of which is rupees 15 per meter. There is a breach of condition, and now Y can reject the goods. However, if Y accepts, he can claim the damages. Means in this case, the buyer has treated the condition that it was a warranty only. Third is acceptance of goods by buyer. If the buyer has accepted the goods, then in that case, it would be treated as a warranty. It would not be treated as a breach of condition. So here also there is a further demarcation, means the where the contract of sale is not severable, it's not divisible, and where the contract of sale is divisible. Let's see the examples of both cases. First, when the contract is not divisible, a contract was made for the sale of wheat on CIF terms. The buyer took the documents and resold and delivered part of the wheat without making a proper examination thereof. The wheat having been found of inferior quality, they claimed to reject it. It was held that the resale and delivery of the part of the wheat was an act inconsistent with the ownership of the seller, and the right to reject the goods had been already lost. In case of second example, a dealer ordered from a manufacturer horns of different descriptions and prices. The horns were to be delivered in several installments. The buyer accepted some installments but rejected others on the ground that they were not of merchantable quality. So it was held that the dealer was entitled to do so, because in this case the whole contract of sale is divisible. The items can be divided. So in this case, a few items can be accepted and other can be rejected.